impede too much on the time for our presenters. So I'll go ahead and get started. And Jonathan, you can go to the next slide here. I want to say welcome to all of those who are joining us today for today's Social Media 101 for Prosecutors. This is part 2 of our webinar series that we are hosting in conjunction with our colleagues with the National District Attorneys Association. My name is William Moore with OJJDP NTTAC. And before we get started, I want to go over a few housekeeping items to keep in mind during today's web event. Next slide, please. Please note that today's web event is indeed being recorded and will be published on NTTAC and OJJDP's YouTube page. Next slide, please. Past web events are archived on our YouTube page where you can go and view those web events. If you would like any supporting materials related to the web event, you can please go to the OJJDP TTA Help Desk to get access to any of those supporting materials. Next slide, please. If you're having any trouble accessing any materials, and we'll actually, for today's web event, provide a Google link where you can get access to a PDF version of today's web event, then we will have that where you can easily go and get access to a PDF of today's document. If you are having trouble accessing that PDF in that web Google Drive there, please contact the OJJDP TTA Help Desk and we can make sure that you get access to that document. For optimal audio, please make sure that WebEx is dialing out through a phone line. This, again, is for the most optimal audio for today's web event. If you're experiencing any audio issues, you can simply log out and log back into WebEx, and usually that will correct any audio issues that you may be having. If you're experiencing any additional technical difficulties, just contact me, William Moore, the host, and I can help you with that with no problem. During today's web event, please note that we will indeed ask for you all to send any of your questions to our presenter and to our panelists through the chat. What we're asking is for you to go to the Send To option, and under Send To, or the To option, select All Panelists or Everyone when you're sending your question. Again, when you're sending in your question, please select All Panelists or Everyone before you hit Send, and then you'll hit Enter and send your message. Next slide, please. Now, please help us count. If you're viewing by yourself, there's no need to type anything at this time. However, if you're viewing in a group, meaning there's more than one individual with you, please go to the chat window and send to everyone or all panelists the total number of additional people in the room with you today. That is additional people, not including yourself. If you're viewing by yourself, there's no need to type anything at this time. Next slide, please. After today's web event, individuals will get an automated email that will include your certificate of attendance. If you are looking to get access for a certificate for individuals who are in the group, there is a link that was just posted in the chat where you can click on that link and fill out our validation form there, and we can assure that you can get access to the certificate for those additional people that are in the room with you today. Again, if you're viewing by yourself, you will receive an automated email that will have your certificate of attendance. Next slide, please. This is a brief showing of today's agenda. Next slide, please. And now I will turn today's web event over to Susan Broderick for today's webinar. Susan, take it away. And Susan, you may be on mute. And let me go here.
Can you unmute? Okay, I was trying to do it.
There you go.
Can you hear me now?
Can hear you now.
Thank you.
Yep.
Okay, sorry everybody. Welcome. Very excited that you're all joining us today. And this is the second part of a two-part series on social media and sort of an overview for juvenile prosecutors and other juvenile justice stakeholders. This webinar series came about because last year we had a meeting with a number of senior-level juvenile prosecutors from across the country, and they were talking about how we really need to start training on social media because it really is the next great frontier for us in court, and given, especially now with COVID and what's going on with social media. So last week, many of you joined us for our presentation by Katie Greer, where she really gave us an overview of what's out there. And today we are so lucky to have with us Jonathan Holbrook. Next slide, please. So Jonathan is he's a prosecutor educator, which I love that. And he's at UNC, and I actually learned about Jonathan's work through other colleagues, and he really just helps prosecutors and trains us. And I was telling him right before the presentation today that I so enjoyed going through his slides. I felt like I was back in law school and learning about evidence. And a lot of you submitted questions about admissibility of this evidence and authentication, and Jonathan is going to cover it all. So without any further ado, I introduce to you Jonathan Holbrook, and who's going to talk to us about digital evidence. Wait, we have one more thing. Next slide, please. So I meant to, this is actually new, we just put this in because last week after Katie's presentation, I was watching the news and I saw this, and it was, I don't know if any of you have heard of it, but Dr. Laura Berman was talking about her 16-year-old son who on Snapchat purchased illicit drugs, and they were laced with fentanyl, and he overdosed and died. And, you know, seeing this the night after we had done the first part of the social media, because I feel like those of you who are on the front lines right now, you are facing just a stream of different issues. And we have, you know, the opioid epidemic, fentanyl, all of the problems with addiction coupled now with social media. So seeing this as we were kicking off our social media, I just think, again, stresses the importance of this, getting this information into evidence and looking at all the different issues associated with it. So without any further ado from me, Jonathan, please start your presentation.
Yeah, thank you. No, I think
you.
that's a perfect introduction. You're exactly right. I mean, that's where the issues that are happening, and that's where a lot of those issues are happening. So I think this just could hardly be any more timely. So yeah, no, I appreciate the introduction. As Susan mentioned, I worked as a prosecutor for about 10 years, and now I work at UNC Chapel Hill School of Government in this role where I sort of just research and write and train and advise and try to help prosecutors in North Carolina and elsewhere. So as Susan said, I'm sure a lot of you were here for part one of the program earlier, looking at those larger trends and issues in social media. And I am going to continue to focus on social media in this second portion of the program. But I'll also just go ahead and say that I think a lot of what we're going to talk about really applies to all the other stuff we call digital evidence in criminal cases, you know, emails and text messages and voicemails and blog posts and all of that. So my real focus for today is this. You know, let's say you have something like a social media post and you want to use that as evidence in your case. So how do you get behind the screen and prove that it's real? You know, prove who wrote it. If it's too small or too blurry to read on your screen, the little cartoon there says on the internet, nobody knows you're a dog. And I put it on here as an introduction just because I think it's funny, but also because I really think that sums up this key issue that we're struggling with a lot of this social media and digital evidence about showing who it really is. So we're going to be looking at two main topics today. We're going to look at how did you obtain this evidence that you've got? How did you actually get it into the court? And then once you have it, how do you make sure that it's going to be admitted at trial? And I think in an interesting way, the answer to the first question can be helpful in figuring out how you want to answer the second question. So Before we dive in too much further, I just need to mention a couple of points. The first is I just wanted to mention that what we're doing here today is supported through this grant that you see up there from the Office of Juvenile Justice and Delinquency Prevention. So we certainly appreciate that. And then the second point I think they wanted me to make is that whatever we cover today, these thoughts and these opinions are mine alone. I'm certainly not speaking for DOJ or for anybody else. These are just sort of my thoughts and suggestions and some cases we're going to look at about this issue of social media. And again, I know many of you were here for part one, so you probably heard some about this, but the point I wanted to just stress is that social media is absolutely huge. Just to set the stage for today's discussion, let me reiterate a couple of things that I think were touched on in that first program about what it is that gets used and how much it gets used. You know, whether we're talking about Facebook, Instagram, Twitter, Snapchat, Vimeo, a million other apps that I don't personally use, but just about everybody else in the country does. That usage has just been increasing every year, and you can see that reflected in those images up on the slide. And you know, there's an interesting difference based on age in terms of what people use. Old people like me are on Facebook, and you'll see throughout this program, whenever I'm trying to come up with an example of social media, Facebook is always the first thing that comes to mind for me to say. But younger people don't really like Facebook as much anymore because it's full of old people like me. So you'll find them on Snapchat or Instagram or YouTube, these other things. But regardless of which particular app people prefer, the numbers and the usage statistics for them are just astonishing. This study found that out of the eligible population, people over 13 who are allowed to have these accounts, 83% of us here in the US have at least one active social media account. And the average person has 8.6 different social media accounts in 2020, which is a big increase from even just a few years ago. In 2014, it was more like 4.8. But then the even more astonishing is that the average person spends about 2 hours and 3 minutes every day on social media. And if you do the math, that comes out to 2,080 days over the course of your life. 5.7 years of the average person's life is spent on social media. And I think that's especially true now when we're all stuck at home for the pandemic. We're here more than ever. This is where school and work and socializing and dating, it's all happening online. So our lives are basically happening online, which means that as part of life, we also have fights and threats and conspiracies and everything else happening on social media, which sort of leads me to my next point. And I think Susan gave us a great example of that in that opening example of the, person finding the drugs and making that connection through social media. But, more broadly, how does this translate for you as potential evidence in your case? If you're a prosecutor working in 2021 and you signed up for this program, you probably don't really need me to tell you that social media can be a great source for evidence in criminal cases. But in case that's unclear, let me just stress that it absolutely is. Maybe you've got screenshots captured by your victim or printouts of pages by an officer, or maybe it's a download of the entire account from the service provider. But either way, it can be incredibly useful evidence. People will post almost anything on social media. They're posing next to the stolen property, admitting to the crime, making threats, flashing gang signs, whatever you can imagine. Somebody has probably posted that on social media. And I think a really good recent example is everything we're seeing about these riots that happened at the Capitol back on January 6th. And now, we've got something like 150 or 200 people facing criminal charges. And it's being discussed a lot in the news that people were posting photos and videos and statements about their own criminal conduct in breaking into government buildings or stealing government property. I looked at a news article about that recently that had some incredible examples of that, where "this is me," one man posted on Instagram with a hand emoji pointing to himself in a picture of the violent mob descending on the Capitol. "So we've stormed Capitol Hill, LOL," one woman texted while inside the building. "I just wanted to incriminate myself a little, LOL," said another about a selfie. And even the defense attorneys have acknowledged what a problem that kind of evidence poses for them. This one attorney said, "I'm not a magician. we've got a photograph of our client inside a federal building with government property. So, and I think he's exactly right. It can be incredibly useful evidence. And, you know, when I've talked to prosecutors about this before here in North Carolina or other places, and what I've learned is that different prosecutors have very different comfort levels with this evidence. If you are already very familiar with it, you feel confident about laying a foundation for it, talking about it, using it at trial, that's great. That's wonderful. I hope you still find something useful in this presentation today. But I've found that a lot of prosecutors don't feel that way. I mean, maybe they just don't use social media themselves, so they aren't all that familiar with the tech, or they're worried about laying a proper foundation, or just worried about explaining it to the judge so that the judge will understand that we've laid the right foundation. And my big message for today is this: it does not have to be complicated at all. I think the title for this on the registration for the course called it Demystifying Digital Evidence. And I think that really sums it up perfectly. The processes and the rules and the legal principles for this kind of evidence are really no different than what you do every day in all your other cases with non-digital evidence. So, you know, when you've got that DVD with 15 gigabytes of data from a service provider, I mean, that's not really any different than just a stack of papers that you're getting from an employer or a bank or a school. And, you know, even a social media post somewhere out online somewhere, I mean, that's not really, from an evidence perspective, any different than a note or a drawing written in somebody's school yearbook, or a note or a letter sent through the mail. And so the purpose of this program today, what I'm going to do in the next maybe 75 minutes or so, is to explain where can I say that from? Where is that coming from? How can I say that? Prove it with the rules of evidence, back it up with some case law so that you can easily do the same thing with your judge the next time you're arguing about these issues in court. So if John is right and it's not really all that complicated, then why does it feel more complicated, right? I mean, why did all of you sign up for this program today? I think it's a little less true today than it was even just a few years ago, but still, the idea persists out there, and if not you, then maybe just with your judge, that any kind of digital evidence like social media is just confusing and it's technical, and so surely there has to be this huge amount of background work done to shore it up and get it admitted, right? In other words, we need to hear from some qualified Geek Squad witness who can talk about IP addresses and transfer packets and account verification and all of that, so that we can be 100% sure that it's real and it's right. Basically, digital evidence just seems different and magical, and we haven't seen the prosecution put on a magic show yet, so objection. And I'm saying don't fall into that trap. It is just evidence, and authenticating it is a low hurdle. So to show you what I'm talking about, I want to look at a case we just had a few years ago here in North Carolina, a case called State versus Ford. And what happened in this case is the defendant's pit bull named DMX attacked and killed an elderly man. And so the defendant was charged with manslaughter for letting this dangerous dog run free. And the defendant denied that. He said he didn't know the dog was dangerous. So part of the state's evidence at trial was offering screenshots from his MySpace page, if anybody remembers MySpace. And what those screenshots showed was that someone had posted videos of the defendant's dog with titles and captions like DMX the Kill a Pit, and after a short fight, he killed that mutt. So at trial, there's this fight over authentication, and the state is saying, look, we know the defendant is the one who posted these videos and wrote those captions showing that he knew the dog was vicious, and we say that because look at the account name. The account name is FlexUGod7, and his nickname was Flex, and just the fact that the account had these pictures of the defendant and pictures of his dog, and the defendant is objecting to that. I mean, he's basically saying there's no authentication here. You don't really know that it's his account. The lawyer says, simply because it's been said that this page or these pages are in my client's name do not necessarily mean that he posted any of this material. And then it picks up what you see on the slide. I don't know if there has been what would need to be done to trace this back to an IP address or whatever, so objection. And the trial judge admitted it, and the Court of Appeals said that that was correct. And the Court of Appeals emphasized that it's this low hurdle of authenticating the evidence. Here in North Carolina, it's only prima facie showing. And the court said this. The court said, while tracking the web page directly to the defendant through an appropriate electronic footprint or link would provide some technological evidence, such evidence is not required in a case such as this, where strong circumstantial evidence exists that the web page and its unique content belong to the defendant. So that circumstantial evidence from the contents was enough to authenticate it as being his. Now, let me just mention, I actually met the lawyer from this case. He came to a program I was doing where I talked about the case, and so we spoke afterwards. Could not have been a nicer guy. So I'm not making fun of anybody, despite the caption here on the slide. I'm just mentioning it because I think it's a perfect example of that kind of vague or all over the place objection that you get from the defense attorneys. So when they make that kind of murky or vague objection, it can be hard to pin down exactly what they are saying that the state failed to show, which makes it hard to know how to answer it and demonstrate that you did lay a proper foundation for the admissibility. And I think the way that you fight that is by understanding the real arguments buried in there, maybe even better than the defense attorney who's making them. And then you can explain to the judge why that objection is wrong and the evidence should come in. So what is it that the defense is trying to say when they just sort of say, foundation, objection, authentication? I think it's three different things that are sort of wrapped up in there. And the first is authentication. And there's a couple of related issues or challenges in here, right? I mean, number one, how do we know that this post or that these records are real, that they're the real ones from YouTube or Facebook or whatever it is, that they weren't corrupted or doctored or fake? And then even if it is real, how can we be sure that this defendant wrote it or said it or posted it? So that's one. And then second, there's this issue of best evidence or original writing. Because if you think about it, real digital evidence is just, it's ones and zeros floating in a magnetic field on a hard drive, probably out on a server farm in California somewhere. But state's exhibit number 5, the thing here in court, is not that, right? This is just a printout of a copy of a download. And so that's not the original. That's not the best evidence for this writing. So arguably it's not admissible. And then third, there's this hearsay aspect to it, that this evidence is going to contain statements, out-of-court statements, may be by someone other than the defendant. And if you've got that, then you've got a hearsay issue that has to be addressed. So what I want to do is work through these in reverse order, basically starting with what I think is the easiest to tackle, which is hearsay, and then working up to what I think is the most difficult, or at least to some people, what seems like the most confusing issue for social media and digital evidence, which is authentication. All right, so let's start with hearsay. Obviously, this is not unique to electronic evidence or social media, but it comes up enough to talk about it and make sure that you're ready for it ahead of time. Yes, if this is an out-of-court statement by the declarant offered for the truth of the matter asserted, then sure, you've got a hearsay issue that you need to deal with to get that statement admitted. So how do you do that? I think there's 3 different components to this to think about. First, obviously, is all of your exceptions or things defined as non-hearsay under Rule 801. It's the statement of a party opponent. It's a co-conspirator statement, or maybe it's an adopted admission, something someone else said, but this defendant or this declarant adopted that statement and acknowledged it. So all of your, Rule 803 hearsay exceptions or defined as non-hearsay, all of those are going to apply to these statements just like they would anywhere else. But then second, there's all the cases where it's not hearsay because it's not a statement. A lot of electronic evidence is not a statement because it's not from a declarant. When you're just talking about computer generated data, for example, like these phone records or account information, that computer generated data is non-hearsay because there's no declarant, or other things that are just simply not statements, like photographs and videos and other recordings. So that's a second component. And then third, you've got things that are not hearsay because they're not being offered for the truth of the matter asserted. And I think it's a pretty common experience, I'm sure a lot of you had, as soon as your witness says something like, so then he said to me, you get the immediate hearsay objection, right? It's almost like a reflex. But not every out-of-court statement is necessarily hearsay. So if you've got these other comments, other chats, other posts besides the one from your defendant or whoever the declarant is, I mean, if it's just a question or a setup, then if it's offered for that non-hearsay purpose, like effect on the listener of, this is what prompted the comment I really care about from the defendant, then you've got the argument that it's non-hearsay for that reason as well. So, like I said, this is not complicated. It's not unique to this type of evidence, but certainly something to think about and be ready for if you're going to be offering that kind of evidence. So that's that third category. Let's back up a little bit and talk about that original writing or best evidence issue. This is that component number 2 of the defense objection. quick recap of just what these rules are. I know they don't come up all that often. People may not have really looked at these a lot since law school, but original writing best evidence applies when the content of a writing is at issue. And of course, every state organizes and numbers these a little bit differently. I'm using the numbering system that we have here in North Carolina, and I think is the same for the federal rules. So bear with me if it's a little bit different for your state or your jurisdiction. But either way, the basic principles are pretty much the same for all of us. Rule 1002 says the original of a writing is required if you want to prove the contents of it. So what is a writing? Well, a writing is what you think it is: letters, words, numbers, or their equivalent, set down by typewriting, handwriting, printing, etc. So, and again, in some jurisdictions, your rule may be a little bit more narrow. Maybe it only applies to writings. For us here in North Carolina, and I think a majority of jurisdictions, it says something along the lines of, to prove the contents of a writing, recording, or photograph, the original is required. But either way, the point is, yes, if you've got electronic writing like chats and messages and posts off social media, then the rule likely applies. And so you have to satisfy that rule if you want to prove the contents of that writing. So how do you do that? Well, there's several ways to do it, and none of them are really all that difficult. First of all, like Rule 1001 says, many things are originals. So contrary to how we normally think of that term, there can often be more than one thing that counts as the original of that writing. And that's especially important when we're talking about social media and other digital evidence. The commentary to the federal rules and many state rules will explain that for electronically stored information, original means any printout or other output readable by sight that accurately reflects that information. And that just makes sense. I mean, you and I, we're human beings. We can't process these electronic ones and zeros. We have to see it printed out or rendered on a screen or something like that. So in order to interact with it. And so that manifestation of the data that we are interacting with, that is the original for us. And even if that concept is not explicitly spelled out in your jurisdiction's rules, I think you'll see it developed in the case law, and we're going to look at a couple examples of that on this next slide. So that's one, is that a lot of things are originals, including printouts or other readable by sight versions of the data. But second, you've got that rule dealing with duplicates, Rule 1003, and that says most of the time you can use a duplicate of the original, something like a photocopy or a screenshot or whatever it is, the same way that you would use the original. It's admissible to the same extent as the original would be, unless there's a genuine question about its authenticity or a reason it would be unfair to admit it. So again, you pair that up with the definition of what counts as a duplicate, which is back in Rule 1001, and that explains that it's a counterpart produced by mechanical, photographic, chemical, electronic, similar processes. So that covers all those normal methods you would think of for creating a duplicate you're going to have in court, like copying the hard drive or printing out the photographs or making photocopies of something that was printed. All of that for these electronically stored data or copies of hard drives and so forth, all of those are going to be duplicates admissible to the same extent as an original, unless there's some genuine question about their authenticity. So that's another important one. And then finally, there's this rule about offering other evidence. Now, certainly that's less common, but it could absolutely happen. I think somebody in the pre-submitted questions mentioned things like Snapchat, where you've got disappearing messages, or the same thing could come up if the original's simply been lost, or maybe that account has been deleted. So this is the rule that says if the original is lost or destroyed and not done in bad faith, then you can prove the content in other ways, like having a witness testify about it, or a printout of it, or whatever else you might have could satisfy as other evidence of the original content. Again, like hearsay, point here is that it's not a big barrier as long as you know the rules and you can explain them to the judge and point out why it's allowed. So, again, obviously this will vary a lot by jurisdiction depending on exactly how your rules are structured. So you'll have your own cases, but I just wanted to look at a couple that I think are good examples of illustrating how this works on this best evidence or original writing portion of the objection. One that I noticed here was this Gilman case out of Massachusetts. case where the defendant was a middle school teacher and he was convicted of sex offenses against a 7th grade victim that he started talking to on Facebook and exchanging a bunch of messages. And his wife eventually saw some of those communications. Law enforcement was brought in. So the evidence against him at trial includes thousands of messages and chats that are recovered off of his computer. And so for use at trial, those chats were copied off the computer and then printed out into spreadsheets, and that's what we're using at trial. And the defendant made a bunch of arguments on appeal about relevance and authentication, but specifically here, what I wanted to talk about is he's objecting on this best evidence ground. You know, he's contesting the idea that the printouts or the spreadsheets are not the originals of the messages or the chats, and the appellate court disagreed for exactly what we were talking about. They're affirming, that's what you see on the slide, they're affirming the trial court's decision to admit the evidence and saying, look, you don't need the original in the way we were talking about. Like, you don't have to actually pull the hard drive out of the Facebook server in California and bring it into court. That's not necessary. That either these printouts could themselves be deemed originals, or alternatively, even if what you've got is a duplicate of the original out on a server, that would be admissible to the same extent as the original would be. So, you know, whether it is an original or a duplicate, either way, admissibility pretty much the same. I think that's a good example implementing those rules. And one other I just would mention is this from Arkansas. Another sex offense case, but it addresses some additional issues. This is another case where a defendant goes into an internet chat room, meets what he believes is a 14-year-old girl, although it's actually an undercover officer. So most of you know how these cases work. They start talking, make an agreement to meet up for a sexual encounter, and the defendant shows up for it, and he's arrested. And you know, law enforcement had all these chats that they had done with him saved on a hard drive, and after each one of those conversations, they had a program to print them out and make a transcript of it. So when the case comes to trial, the defense says, I want our expert to look at the hard drive, and the prosecution says, sure. But then there's a problem because the hard drive has actually been destroyed by a virus. So it's no longer here. And the defense moves to dismiss, or at the very least, suppress the evidence. And the trial court says no, for the reasons we just talked about. You know, that the printouts themselves would be originals, or alternatively, at worst, they would be duplicates of the original. So they're going to be admissible to the same extent. And failing all of that, even if this hard drive was the only thing that we call an original, it's been lost or destroyed. So we can offer other evidence of contents, like the printouts of those chats. So, you know, not tough, and I think the cases back up what the rules say, as long as you know them ahead of time so that you're ready to address it. All right, so let's look at that third, the first prong, really, of what I'm calling that sort of murky or confusing defense objection that we're trying to answer, and that's this issue of authentication. So before we talk about how you're going to authenticate this evidence, let's talk about what authentication is, because ultimately, obviously, that's what drives the rules and drives what we need to do. And I think there's three parts to this. And the first is that when we say authentication, what we mean is identification. It simply means you have to show that the thing is what it purports to be. And that's not necessarily complicated. You do that all the time with physical evidence, right? Think about that slide I was saying. What if this wasn't digital? So, officer, what is this? Oh, that's the knife that we found in the defendant's bedroom. Well, how do you know that? Because I recognize the scratched up handle, and I put my initials and the date on it when I logged it into evidence. You just authenticated that knife. And I think you can do the same thing with electronic evidence or social media. Victim, what is this? Oh, that's the threatening Facebook message that he sent me. Well, how do you know that? Because it's from his account. That's where I always talk to him. And then we talked about that message when I saw him in person a week later. I think you just authenticated that Facebook message, and we'll look at some cases to help back that up. But that's part one. It's identification. And then second, authentication means relevance. Because again, using that same example of a threatening Facebook message, if we don't show that it's a message from the defendant, then we're not showing that the defendant is culpable of anything. And without that, it's not relevant in this defendant's trial. And so for social media, this issue of authorship or ownership is a key authentication question that we're going to be coming back to again and again. So it's identification, it's relevance, you need to tie it to the defendant, but paired in with that, I would also stress It is a low hurdle. It's in most jurisdictions, it's just a prima facie showing, but or at worst, you've got a preponderance of the evidence. So how sure, in other words, does the judge need to be that this social media post is real and is from the defendant? It's not reasonable doubt. It's not clear and convincing. It's just this lower prima facie or preponderance level showing that it is what it purports to be, and it is connected to this defendant. I think that's worth remembering and stressing. You know, it's not absolute certainty, and doubts about that will go to the weight that it gets, not to the admissibility. So this is just one man's opinion here, but I think that some courts have not always been faithful to these principles when it comes to electronic evidence like social media and text messages and things like that. Sometimes it seems like the trial courts are leaning towards wanting the prosecution to show something more along the lines of certainty. You know, that they want the state or the prosecution to rule out any possibility that this evidence could have been corrupted or manipulated, or that it's a deep fake or spoofing. They've taken reasonable concerns about the integrity of digital evidence and allowed them to prevent admissibility for reasons that really more properly go to arguments you would make to the jury about how much weight to give it. Courts, I think, in some ways have what I would call technical heebie-jeebies. They're just, you know, it's digital, it's technical, it's weird. I'm worried. And so what we're going to do today with the rest of this time is work through these arguments and identify the rules and the principles and the cases that I think will give you the tools you need to help the court make the right decision on those objections. So how do you do it? Now that we know what authentication is, identification, relevance, low standard, how are you supposed to do that, especially with social media? Yes, it's a low hurdle, but how exactly do you get over it for this kind of digital evidence? You all already know, if I say authentication, you know that for virtually any kind of evidence we're talking about, we'll come back to Rule 901 about authenticating evidence. But let me start with just an important reminder about that rule. This is not a formula. This rule is not like hearsay exceptions under 803, where there's a checklist of just very specific and discrete ways that you're going to get that evidence in. You know, you have to exactly satisfy one of these exceptions under the rule. That's not how Rule 901 is set up. Virtually all states and the federal rules have this second part of Rule 901 that gives you a non-exclusive list of examples and suggestions and options of how you could go about making that showing for the first part of Rule 901 that it is what it purports to be. I know there are some jurisdictions where that's not actually part of your rule, and so those methods and examples come more from the case law, but the basic principles here are the same. The point is that these are non-exclusive examples and options of how you can get there. So of that list of suggestions and examples, I think the three most common for social media are the ones I've put up here on the screen. Testimony of a witness with knowledge. If you've got somebody who can come into court and say, this is what it purports to be because I know and I'm telling you. And we'll look at some examples of that. That's obviously going to be one of the ones you'll lean on. But the second is this distinctive characteristics and the like. I think for most of you that would be 901B4. It's the example that says you can look at the appearance and the contents, the actual contents of the evidence. And when you look at that in conjunction with the facts and circumstances of the case, that right there can be enough to show you that it likely is what it purports to be. And then third is this other one about the process or the system. You know, if you think about, for example, doing an extraction on a cell phone under Cellbrite or XRY, you know, the testimony that the process we use produces an accurate result. And that's how you can know that the result I've got here in court is what it purports to be. We'll look at these in more detail as we look at particular examples, but I think these are the three under Rule 901 that we're going to be coming back to again and again. So broadly speaking, that's the how. But I've got one last thing before we start applying those methods and looking at the specific examples. What we call social media evidence. It could come from a million different apps, a million different formats. They're inventing new ones every day. I don't think you could ever really keep up. But if you think instead about how you got that evidence, I think that 99.9% of the time, you could put it into one of just three basic big categories. Now, this is not anything official or scientific. It's just something that I made up. But I think it can be a helpful way to approach the topic and organize your thoughts and plan out how you're going to get it in. So what are, I'm saying, the 3 sources of basically all social media or digital evidence? Well, one of those is you're getting it on a server. You know, you've sent your search warrant to Facebook or YouTube or whoever it is, and so you've got these records coming straight from the service provider. It came right off their server, and now you've got it on a DVD or a thumb drive or whatever it may be. So that's one. You're getting it right off of the server. That's one category. The second category would be that you've already got it right here in your hands. You know, so that's the hard drive we pulled out of the computer in the house, or the messages on the cell phone that came out of the defendant's pocket when he was arrested. I don't need to go to the service provider because here it is right here. That's a second avenue for getting this evidence. And then the third is what I call in the wild, and we'll spend a fair bit of time talking about that. But you know, these are the ones, they're just out there somewhere, right? That's the stuff that's just out on the internet somewhere. Somebody saw it. So it's a social media post or maybe a message coming from an unknown account. So those, I think, pretty well describe anything you're going to encounter as social media or digital evidence. So what I want to do with the rest of our time is look at each one of those, use a typical example that you might have in your next case, and then we'll work through those objections, authentication, best evidence, hearsay, and see how it plays out for that type of evidence. So let's do that with this first one. What I'm calling method number 1 or source number 1, it's the stuff on a server. So this is where your officers, they're doing their investigation, they got a search warrant, they sent it to Facebook, and you get that big pile of data coming back from Facebook, YouTube, AT&T, similar to what you would do with the phone records. So now you have all sorts of great stuff in there that could potentially be useful. You've got the company's data with IP addresses and who accessed the account and date and times and location. You've got the subscriber information, you know, the account holder name, maybe addresses, phone numbers, credit cards. And then most importantly, of course, you've got the actual content. You know, you've got the substance of the posts and the messages and the chats, the pictures, all the stuff that was submitted through that account. So now here you are in court, and you've got that DVD or you've got that thumb drive with your silver bullet evidence sitting in there, and when you hand it up, they say objection. So what are they objecting to, and then how do you get past that? Let's take everything we just ran through in the last 45 minutes about understanding authentication and objection and best evidence, and see how that works with this category or an example. So for this example, you've got these Facebook records. Let's look at how those objections play out for each of our 3 different categories. The first one, like I said, is authentication. Now here, I would say, don't get bogged down in technical jargon or make this any harder than it has to be. Remember those key questions that we have to answer for authentication. How do we know it's real? And how do we know it's linked to or from this defendant, right? Because that's what makes it relevant. Well, we can show that in 2 different ways. We show that by using that 901B1 for most of you, the witness with knowledge, somebody who can say, you know it is what it purports to be because I know that it is what it purports to be, and I'm telling you that it is what it purports to be. So that's when you're bringing in a live, the live records custodian is coming into court, or maybe you've just got an affidavit from that person, if that's allowed for you in this particular context, like what you would do for a business record. So when that witness comes in and says what these things are, that's what they're doing. You know, that's what's happening. They're testifying as a witness with knowledge. And that's one way to go, but you can also do that under those distinctive characteristics we talked about for 901B4, the content and the substance in conjunction with the case. That's exactly what was going on in that Ford case from North Carolina that I mentioned at the beginning. So here you're looking at the details of it, like the name, the account holder, the credit card, the address, all the stuff in the records themselves that points to this defendant. And then the content of that account. So the pictures, the happy birthday messages, the statements about things that only he would know. So all of that points to the distinctive characteristics indicating that it's him. Maybe there's some other, in rare cases, things that might come up. You know, maybe you've got a witness with knowledge because somebody saw him write that post. You know, it should be another way to go. But usually it's going to be this witness with knowledge from the company or the distinctive characteristics. But whatever it is you've got, use it all. remember that point I was stressing, that 901 is just a set of examples and suggestions and options. It's not an exclusive and discrete list. So, you can mix and match, right? A little from column A, a little from column B. Everything you've got that goes towards showing those two things, show me that it's real, show me that it's from him. That's how you authenticate it with whatever it is that you have. So what about this original writing or best evidence issue? Well, those rules and those cases I was talking about eliminate that. You can argue that the printout of this that we got from Facebook, the printout of the account, that is an original because we're humans and that's how we interact with data. Or even if that is deemed a duplicate of the Facebook hard drive, there's no reason to doubt its accuracy when it's coming straight from them. So it's admissible exactly the same way that the original from their server would be. And then finally, what about the hearsay objection? Well, find your exception and get it in, whatever that may be. For the defendant's own statements that he's making in posts and messages, probably going to be admissible as a party opponent. And then the records themselves, in some cases, we're going to talk about this in the case examples on the next slide, it may qualify as a business record because the company is keeping all of this for their own business purposes, like billing and targeting ads and so forth, and the records made at or near the time. Or if it's not a business record, then the reason it's not a business record is probably because it's computer-generated non-hearsay. This just automatically generated data from a Facebook server. Well, that's not hearsay anyway. So all that stuff they've got about the dates and the times and the locations and the IP addresses, that's not a statement from a declarant. That's just automatically generated computer data. But again, with the stuff you really care about, the content of the chats and the posts, probably going to be admission of a party opponent or whatever other hearsay exception would apply. So all of that sounds good in theory, but does the case law back that up? Yes, I think it does. So I want to look at just a couple of examples pulled from various jurisdictions that demonstrate using these methods that I'm talking about. And these are what I think of as low-tech foundation for this kind of, for this category number one of coming off of a server. And then I'll look at some options that dig a little deeper into the more technical or complex ways of doing that. But one case you could look at, just to pick an example, is this, Glover, a case out of Colorado. Classic application of the rules and the principles that I'm talking about, although it's a fairly unusual set of facts. The defendant here is the head of they call it a family of homeless people and runaways, and the victim in this homicide is a member of that family. He's found murdered in a gutter, and the defendant is arrested on something completely unrelated, but they find one of the victim's fingers in the defendant's backpack. So, of course, they make that connection, start investigating, and what they figure out is that the defendant was mad at the victim for owing him money and talking trash on Facebook and so forth. So the defendant ordered another person in the group to go kill the victim in retaliation for that and brought back the finger as proof. Anyway, point is, the prosecution's evidence includes all kinds of incriminating messages about the defendant green lighting the hit on the victim and ordering this other person to do it and so forth. So here, the prosecution did exactly what I'm talking about. They get these records directly from Facebook, and they're offered at trial with a records custodian affidavit, and then printouts are admitted as business records. And the appellate court says, actually, we don't think that was the right way to do that. We're not convinced that these really are business records because there wasn't sufficient evidence showing that they keep them and rely on them for their own business purposes. So no, we don't think these really are business records in that sense, but all that same foundation that you would offer for a business record met the burden of satisfying that part one of authentication, showing that they are what they purport to be under Rule 901. In other words, they're not business records, but you still showed that they were reliable because that uncontested affidavit said, these are our records. They are automatically generated. We keep them, et cetera, et cetera. So all that same stuff, even though it wasn't technically a business record, it still did what it needed to do of showing that it was reliable. And then there's that second component of linking it to the defendant. And when the court looked at that, they said, all right, so we know that these records and the statements in these records are real, but do we know that they're from the defendant? Yes, we do, by using that kind of 901B4 distinctive characteristics analysis. And they looked at, for example, the account was registered in the defendant's middle name and last name, and there's photos all over the account that of him. The detective testified that a cooperating witness had identified it as being his account and one that she used to communicate with him. It's got his phone number, all these other details that link it back to being him, his nickname, and so forth. And so they said, look, you showed not business records, but you showed that they're reliable. They came straight from the source. They're real. You satisfied that. And then we linked it to the defendant based on the name and the photos and the phone number, proper to let it in, conviction affirmed. Another similar example here, State versus Griffith, an Arizona case. Again, struggling with this business records analogy, even though in many cases they aren't really business records in the traditional sense of having a declarant make a statement, because it's really just this computer generated data and not a statement. But quick fact summary on this one, just for context. The victims came home, their house had been burglarized, there's stolen property like Apple iPads and so forth. So the officers work with Apple and they identify this defendant, Griffith, as a suspect. They interview him and he admits connecting with somebody on Facebook about getting these iPads to resell. So again, they get a search warrant, they get a full copy of the account directly from Facebook through this law enforcement request portal, and the records come back and there's incriminating messages and photos that the state wants to offer at trial. So the argument on appeal from the defendant after he's convicted is saying, hey, that was error. These messages weren't sufficiently authenticated. They shouldn't have been admitted. And the appellate court is agreeing that, again, you're right. We don't think these were authenticated sufficiently as business records. This detective using the Facebook portal to get them, I mean, he's not somebody who can really vouch for the fact that these are, our records created contemporaneously, used for business purpose. He can't say what a records custodian on a typical business records situation would say. But the court goes on to say, even if you got that kind of certification from a records custodian, got that affidavit, it still wouldn't solve your other problem of showing that the statements, the individual statements in here, are connected to the defendant. And yet, despite that, they say that's the bad news. But the good news is they said, but look at what you did show. I mean, you didn't lay a true business records foundation, but you still gave us enough to believe what we need to believe, which is that the records probably are what they purport to be, because the detective could say, look, I uploaded the search warrant. These came directly from Facebook and from Apple. So, we can trust that these records are real. And then as to that second issue of linking them to the defendant, the court again did that similar to Ford. They did that distinctive characteristics analysis to say that shows that the defendant here was probably the person who authored the posts based on sort of how they were found and what they contained. So, his interview with the police where he admits to some things, and the username on the account and the Apple registry, all that stuff in the records linked it back up to him the way that they needed to. So, bottom line, no, the records and the statements, they were not admissible as business records per se, and perhaps are not even business records at all because it's computer generated data. But the way that you would typically lay a foundation for business records got you what you needed to get by showing us that they probably are what they purport to be, and then the distinctive characteristics link them to the defendant so we can believe that these are probably statements from him. I called that low-tech foundation. I'm a big fan of low-tech foundation. I think it is simpler, it's easier, there's fewer witnesses, everybody understands it. What if you want to go high-tech? Maybe this is a really serious case, or you've got a skeptical jury pool, so you want the insurance of getting that Geek Squad testimony that'll do something like match the account to the IP address and to the defendant's mailing address, just to absolutely remove all doubt. Can you do that as well? Sure, of course. There's nothing wrong with that. You see that in a couple of cases, and that can be useful if the defendant, maybe the defendant is just a ghost online or totally anonymous, or there is no account name or something like that. Can you use the IP address as another way of making that necessary link from the record to the defendant? Sure. I just pulled up one example here, US v. Hassan, a federal case. And, that's one where they had these Facebook pages and Google records and YouTube videos in this terrorism prosecution case. And they were able to link them to the defendants by using that. They got them directly from the service providers, but still have that second issue of linking the content and the statements back to the defendants. And they did that by tracing the IP address to the defendants' email accounts and to their physical mailing address. And of course, if you also have these distinctive characteristics like names and photos on the Facebook page or the YouTube page, but IP tracing is it's another link, right? It's another tool in your arsenal to make that connection. And that was what the government did here, and the court said the evidence was admissible. My point is just to say that I think in most normal cases, you don't have to do that. It's just another option, another way of demonstrating those key things of identity and relevance to show that it's linked to the defendant and that we can trust that it's real. Another one of these things I sort of consider, the high-tech options maybe for authentication is what they call metadata. And in my opinion, this is talked about a lot more in the news media or law review articles than it is in actual cases. But in theory, yes, you should be able to do the same thing. If you have a qualified, probably an expert witness who can dig into the metadata of the file, then maybe that would be additional points you could use. You could look at you've got a photograph pulled off social media. Maybe you could look at the GPS coordinates of that file that show where it was taken, or the IMEI number of the cell phone that was used to take it, and looking at the hash value of the file to show that it hasn't been altered since the time it was taken, things like that. I put that case up there, State v. Sasserini. That it's not what you're hoping it is. It's not really a good social media authentication case. I just pulled it up because it was one of the best quotes I could find about this concept of metadata. This was actually just about a video taken with a handheld camera of a fight between a couple of neighbors, and then there's this dispute about whether the video is authentic or real, and the defense is challenging it because their expert is not satisfied with some of what he sees about alterations to the hash value and things like that on the photo. The court didn't find that persuasive. They said that could have just been from copying it to the camera, from the camera to the DVD of the evidence we actually had. But I just thought that quote was useful because, assuming you've got the opposite side of that you do have the uncorrupted hash value and you do have the IMEI number and the GPS coordinates and so forth, I think you could use that as another way to bolster your authentication to show that it is what it purports to be. When I was in regular practice as a prosecutor, this was ahead of my came after my time, I guess you could say, but even then, we didn't have the time or the money or the available experts to do that sort of thing. If you do, more power to you. That's great. I'm just saying, again, I don't think that's mandatory. It's another alternative path of getting to the same place, of just making that core showing of identity and relevance, showing that it probably is what you say it is. And I think most of the time you can do that kind of in a faster and easier way with the low-tech options. All right, so all of that was this big method number one, right? The stuff we get off of a server. And with that toughest issue of authentication, it's just showing that the records are reliable, that they probably are right, and they probably are from the defendant, and that's your focus. This is what I'm calling kind of option or category number two. I don't need to go talk to Facebook or to Google or to YouTube because I've got it right here. I'm not getting these chats and posts and messages from the service provider. It's right here in my hands. And maybe that's because you've got a phone that was taken off the defendant when he was arrested, or the computer that's found in the defendant's bedroom, or a thumb drive hidden in a school locker, something like that. So I've already got it right here. Now, I'd take a quick time out and say, post Riley v. California, that 2014 Supreme Court case about couldn't do the warrantless search and seizure for the contents of a phone, just because you got this device pursuant to an arrest or another search warrant, doesn't necessarily mean the officers are free to just dig all through it. You may need a second search warrant to go do that. That's a separate topic for another day. But my point is just that sometimes the stuff you need, the stuff you want, is already right here in your hands. So when that's the setup for it, what do these admissibility objections look like when you get the evidence that way, and how do we go about answering them? So let's take that example, right? We've got this cell phone maybe taken off the defendant when he was arrested, something like that, and we've got these messages that are right there on the phone. Here, instead of focusing on the reliability of the source like we did for the server evidence a few minutes ago, now I would say what you're thinking about is all of your how questions. How did you find it? How did you save it? How did you preserve it? How did you keep it from being altered? How did you connect it to this defendant? You know, I've said this a few times before. I'll probably say it a few more, that authentication always just goes back to Rule 901, just meeting that low threshold of proving that it is what it purports to be. So with this, these messages on a phone pulled out of his pocket, how do you authenticate that as being his phone containing his statements? Well, because it was in his damn pocket, right? I mean, it really is as common sense as all of that. I mean, I took it off of him. It is his phone, and whatever else you've got, you know, because he said, can my sister come pick up my phone when he was being booked in at the jail? Because there's pictures of him and his girlfriend on the lock screen. Because our cooperator called him on that phone number 100 times during the investigation of the case. So, you know, depending on the circumstances, maybe you've even got a witness who's going to testify, like I talked about earlier, to the accuracy of the process or system used to extract the data from the phone, like the Cellbrite or XRY, you know, and now we have this download or this report pulled from it. Maybe we're authenticating it through that as well. But, you know, generally it's all of these common sense things that tell me that it's his phone. That's your authentication for showing that it's his phone. And the likelihood is then that those messages on his phone, on his accounts, came from him. And we'll see a couple of cases here in just a minute to back up that reasonable assumption that that's probably how this works. The other two portions of the objection, you know, the original writing, the hearsay, how do we answer the original writing? Well, whatever you've actually got in court, I mean, even if that is an extraction from the phone and then we've printed it out, well, again, I think the rules in the cases back you up to say, look, a printout or other visual representation of the data, like displaying it on a screen in front of the jury, all of those are originals of the underlying data that's on the phone, or if not, or at worst, it's a duplicate of that data. But when there's no reason to doubt the accuracy of the duplicate, it's admissible to the same extent as the original would be. So this is similar to the arguments we were making for that on a server. And then, is it hearsay? Well, not when it's his, right? Because then that's a statement of a party opponent. And the people he's conspiring with, his co-conspirator statements are likely going to be admissible just as well. Or, you know, as I said, even these comments from a friend might be non-hearsay or you know, that they are offered for a non-hearsay purpose, effect on the listener. Any of those exceptions, you just treat it the same way you would for any other statement, in, you know, verbal or written statement of the defendant or the other person. So again, that's the theory. It should be that simple. Hey, it's his phone, and hey, he's the party opponent. Is that backed up in the case law? Yeah, again, I think it is. I'll give you a couple of examples that I think show this played out. The first of those was this Atkins case. This was a case where there's a string of burglaries happening at 3 different businesses, and the defendant gets pulled over in a traffic stop in that area maybe a week or so later. He's caught with stolen property and burglary tools, and he's got clothing that matches the burglaries. A lot of incriminating evidence, but the officers also end up searching his phone, and they find good evidence on there, like text messages and tweets about the stolen property. And so the defense is objecting to that. They're objecting on the grounds that it's hearsay. These statements are hearsay, and you can't get that in unless you can show it's an admission of a party opponent, again, meaning you have to show that he was the author. And they say there's no link to that, right? There's no way to prove that he wrote those messages. And the court says, yes, there is, because he admitted to the officer at the traffic stop that it was his phone. and he had the unlock code that he gave to the officers so they could open it up. And there's another social media app on that phone registered to an email address that uses his name. And there's stolen property in some photos on the phone that match to the stolen property back at his house. So, establishing that it's his phone, he's the one in control of it, he's the one using it, that's enough for us to make that reasonable assumption that he's the one making the statements. There's a couple of, I think, good quotes in there in this case. For example, the court says, yes, hearsay is still hearsay, and you've got to find an exception if you want to get it in. Court says this principle holds true universally and applies, excuse me, principle holds universally and applies equally to statements made over the telephone, through text messages, by emails, or using social media, such as Twitter. But then the court makes the follow-up point that I'm stressing here today, which is that things like hearsay exceptions and authentication rules and burden of proof do not have to be any harder or more technical just because it happens to be digital. And so the court says this: although the type of evidence used to prove the identity of the person making the statement may vary based in part upon the medium used to convey the message, the governing legal standard is the same: proof by a preponderance of direct evidence, circumstantial evidence, or a combination of both. And so on these facts, the court said there was plenty of evidence to meet that standard by showing he's the likely author because, like I said on that last slide, it's his damn phone. So of course he's the likely author, and that's all we need to meet the actual burden under authentication. Another case, I think I just saw sort of a question coming in that maybe touched on this. Same idea, but now going the other way. Messages in your hand by way of the victim in the case. So this case, Boyd, was one where the defendant sends a friend request to a 14-year-old girl on Facebook, and she doesn't know him, but it looks like they know people in common, so she accepts it. They start talking, and it begins innocently, but pretty soon the defendant starts turning it into something sexual. So the girl tells her father, and then the father, pretending to be her, makes a plan to actually meet somewhere with the defendant for an encounter. And the defendant shows up. The father is the guy who's actually there, recognizes the defendant as a guy that he went to high school with. So, of course, they call the cops, and then the cops actually do the same thing. They arrange a second fake meeting. The defendant again shows up, and he's arrested, charged with some child exploitation offenses. So naturally, the evidence at trial includes printouts of these social media messages taken off of the 14-year-old's phone. I'll just mention the defendant's phone was wiped clean of everything except for contact numbers, but I think the state sort of pointed that out as kind of in its own way incriminating anyway. But on appeal, the defendant is arguing that that was error, and the defendant says Boyd contends the state should have attempted to identify if Boyd was the actual owner of the Facebook account that corresponded with the victim's account, or subpoena Boyd's cell phone company records to show who owned his phone, what numbers the phone dialed, location of the person using the phone. And the appellate court says, no, they're not required to do that, not in a case like this. The court points out that the Facebook messages from the sender, for one thing, for example, they at least gave the partial phone number that he wanted the victim to use to contact him, and that's the phone number the defendant had on him when he was arrested. Plus the defendant's phone had the victim's contact number in it. And then all of that, again, paired up, as we say under 901B4, paired up with the facts and circumstances of the case, like him showing up at the prearranged meetings and all the other circumstances of the case. So that, the court says, is enough to authenticate it. With this evidence you've got right here in your hand, we can link it to him under that 901B4. And so that was sufficient to do that. So, again, I guess the takeaway from that, in your hands, I'm saying you focus on how. I mean, how do we know that it's him? How do we link it to him? And once you've done that under 901B4, then the statements can be attributed to him as well. So that was number one, was on a server. Number two was in your hands. But I think that what a lot of people came here for today is probably this one, this method number three, what I'm calling in the wild. And I think in a lot of ways, and I think somebody just posted a question, what about, burner phones, for example? Exactly. And I think that last Boyd case is a good transition into talking about stuff like that. So this is where you've got, maybe tweets or even text, but also Facebook, Instagram, Twitter, all the stuff that is just out there posted somewhere on the internet, or maybe it is being sent to the victim from, let's say maybe a burner phone or something like that. So then somebody, the victim, the witness, the officer, they see it or receive it, and then they save it, they print it out, whatever they do. So now here you are sitting in court with a copy or a download of that. This is what I think for many of us feels like the toughest category, right? How on earth do you prove that that is real, or prove that this particular defendant actually posted it? It is not that hard. Trust me, we're going to look at some cases. It does not have to be any harder than what we've looked at in the first two categories. So how do you authenticate it? I mean, authenticating this stuff, obviously that's the main challenge with all social media evidence, but especially for stuff like this that you're just seeing or screenshotting or maybe receiving from out in the wild. How do we know that it is what it purports to be? And I put a couple quotes up there on the slide that I think sum that issue up. And the central fear is that this could be anybody, because now we don't have server records that have that reliable data with, an account name or whatever to link it to the defendant. And we don't have that quick and easy way to link it to the defendant because we've got it right here in our hands. And so, you want to talk about technological heebie-jeebies. I think what you see in that Griffin v. State quote, this is where there's that real fear of this could be a fake account. It could be anybody. We just simply don't know. So how do we do that? How do we make that link for the in the wild stuff? Look, we've been talking about authentication a lot today, including authenticating based on witness with knowledge, distinctive characteristics. As you've probably guessed, those are going to continue to be a big factor for this in the wild stuff. But before we get there, I just want to back up a little bit and talk about some of the other available authentication methods that you have. Now, before we had Facebook or any other social media, there was this other technology that people used to share news and thoughts and opinions with their friends and their family members, and it was called a letter. Now, if some of you are too young to be familiar with this, it's an antique method of communication where marks and symbols were put on flattened out wood pulp, and then they were hand delivered to another person who would then get that message. And, believe it or not, that technology is actually still in use today. That's just a corny, not terribly funny joke, of course, but seriously, thinking about how letters were authenticated is helpful in thinking about how social media communications can be authenticated. Obviously, some of the ways that we used to do authentication for letters do not work for text messages or social media. You don't have the handwriting or a distinguishing signature that might be down at the bottom of the letter. So no, some of those don't work with social media or digital evidence, but a lot of those old principles and old methods from the cases about basic letters do still apply, with the author admitting to it, or somebody saw him writing it, or like we've said under 901B4, the contents, the terms, the nicknames, or just the fact that, it's a reply doctrine, that it's in reference to another communication or things that only this person would know. All of those traditional concepts used for letters would still work exactly the same way for your social media and other digital evidence. In fact, there are a lot of ways to authenticate this stuff, even what I'm calling out in the wild. Now, these are popping up on your screen as I talk, and I realize they're probably, for some of you, they're probably too small to even read. I'm just listing them here on the screen, not for you to memorize all these, but just to sort of shock and awe you with how many different potential ways there are to accomplish authentication, even for this in the wild stuff. In some ways, authenticating this digital evidence is easier than authenticating a letter. I mean, every Facebook post comes with that little profile picture of the author, or at least the account holder, right up there on the side. And, a letter isn't doing that. So in some ways, I think your digital format can be both a blessing and a curse. But, the point of this slide was just to say that courts have found many, many ways to assess the authenticity of this digital evidence. And these examples you see up on the screen are just things that that I've seen come up over the years in various cases, talking about all different types of digital evidence and communications. But I think they make that point I've been stressing, that there is no precise formula. Authentication can happen in many different ways based on different components of direct or circumstantial evidence. Obviously, some of these factors are more powerful than others. You know, a post specifically referencing a previous private conversation is probably going to be more useful than just the fact that it came from an account that the defendant has maybe used, but you know, so have other people, something like that. But all of it, whatever you've got, all of it put together can be potentially helpful. I told you that I've done, I don't know, versions of this or talked about this topic with different groups over the last couple of years. And some of the feedback that I've gotten from people, particularly about things like that last slide, is, you know, that's academically interesting, but not exactly real world trial room practical help. And so here, what I'm trying to do on this slide is just boil that big list down to something that's a little easier to remember and actually apply in your cases, especially when it comes to social media or other digital evidence. Maybe this is too simple, but I'm doing my best. So I just based this list on what I see as kind of general trends in the case law around the country. And for reference, if you don't have it, if any of you want to just jot this other site down, I'm sorry, it's not on the slide, but it's 40 ALR 7th 1 from 2019, Authentication of Social Media Records and Communication. That's just a good collection of cases organized by type and by method from a number of different jurisdictions. And if you don't have something in your own state case law that gives you exactly what you need, check there and you may see something that's fairly comparable to what you're dealing with. But bottom line, here's how I think the most common approaches seem to shake out. Occasionally, yes, you will have a witness with firsthand knowledge or authentication, even for this in the wild stuff. And if you have it, that'll work. You know, so maybe you've got the author admitting writing the communication. So, you know, if your defendant is interviewed and says, yeah, I admit I wrote it, I'm sorry, then you've authenticated it because it's under Rule 901. Or maybe you've got a witness who saw them writing that post or something like that. Less common, but if you've got it, sure, that would work. I think more often you'll be dealing with what I put up there as the second option, which is still using that same life-saving rule, this 901B4, about the distinctive or distinguishing characteristics of the evidence itself in conjunction with the facts and circumstances of the case. Now, the courts don't always perfectly agree about the quantum of evidence that's necessary to make that circumstantial evidence showing for the authorship, but here's my general breakdown. I think generally most courts would say just the name alone, you know, at the bottom of the message, that's probably not going to be enough. And you may find that frustrating, but I think that kind of makes sense. Think about it. If you got a message, you know, an email or a social media message from some unknown account, no other context, and it just says, I'm going to beat you up, signed Jonathan Holbrook. That's probably not going to be enough to authenticate that as actually being a threatening post coming from me. And just like with a traditional letter, I mean, if all you had was a name printed at the bottom, that's probably not going to be enough to authenticate it without more. So moving up then, well, what if you've got something, some evidence of showing the originating account that it came from is linked to the author? So how about that message that I sent you? What if that came from Holbrook at schoolofgovernment.unc.edu saying, I'm going to beat you up, John Holbrook? I mean, that may be enough. It's more support, certainly, for authentication. I call that a question mark. I think it maybe depends on the strength of the link. You know, so for example, does this email address or Twitter handle or whatever it is, does it include the author's name, for example? So Holbrook at SOG is probably going to be more compelling as authentication than Big Nerd at SOG, because the latter obviously is less clearly me. But then, you know, other factors. I mean, does the author have a history of using that account? And does the author have a history of using it exclusively, or is it a shared account that other people are also on? Is there subscriber information and so forth? I mean, generally, whatever you've got, of course, you use it all, but it depends, I think, sort of on the details about just the ownership account. But finally, adding in whatever you've got as other circumstantial evidence, that will usually be enough then to get you over the hump and authenticate that message. So that's all the stuff we were just looking at on the last slide. Did they talk about contents or details known only to the author, or the temporal link between the message and the events that are relevant to the author, the history of using the account, the profile pic, whatever it is you have, you mention all of it. And generally, as long as the account then is sufficiently linked to the author, I think you usually won't need much other authentication to get you, as I say, over that hump regarding authenticating the particular statements. So let's use an example. I said threat posted on Facebook. Let's say, it's just coming from out in the wild. You've got a social media post spotted floating around out there on the internet, or maybe it's even a direct message to the victim on a social media app, but it's coming from some random or previously unknown account out there in the world. So the victim or the officer or whoever else sees it, prints it out, screenshots it, downloads it. Now here we are in court, and that's what you have as your evidence. So taking everything we've been talking about for the last hour and 10 minutes, how do the objections play out for this third key category of social media evidence for authentication and so forth? Authentication, first of all, there's no question that it's real or reliable. I mean, that's pretty easy to establish if you think about it. The witness who found it, saw it, saved it, I mean, they can testify to that fact. Yes, this is an exact copy of the message that I saw online. That aspect of the authentication really isn't your challenge. Like we've been saying, your big challenge for this is proving who wrote it. So again, distinctive characteristics is your go-to starting point. And then you think about all the other different factors, any other different factors you can point to in the case that help you back that up. So, for example, your defendant bonded out of jail at 3 o'clock, and then this threatening message about retaliation comes through at 3:14. That's not just a happy coincidence. That's further authentication for that post. And, again, it's a low hurdle. It's a low hurdle that you have to show. Could someone else have posted this through the defendant's account? Yes, but that isn't likely. So it would be reasonable to conclude that it was this defendant. A common experience is you see your friend posts on Facebook, hey, I just had a great dinner at Dino's Italian Bistro. Okay, well, the next time you see her, do you say, I saw a post on your account about Dino's. I was just wondering, was that actually you? Or was that part of a malicious deepfake conspiracy orchestrated by an imposter to trick me into thinking that you went to Dino's? No, of course not. I mean, you just say, hey, I saw you went to Dino's. What did you have? It's just more probable than not that it was you who went to Dino's and posted about it. And when it comes to this authentication and admissibility, it really is supposed to be that simple. And that's what you can do by just pointing to the distinctive characteristics of the evidence that tie it back to this defendant. In the interest of time, I'm not going to go again on the original writing and the hearsay, but I think those same principles would apply. It's a printout or it's a duplicate, and then assuming I can show that it is this defendant, or that it's non-hearsay or whatever the other exceptions are, then I ought to be able to get over the hearsay portion of that objection as well. So where is the proof, right? Where are the cases backing up this idea that we can succeed in showing who it is that's hiding behind the keyboard on the other end of that mystery message or that anonymous post? I think there's a few helpful case examples that we could take a few minutes to look at. And the first one I'll show you is this, State versus Clemens. This is back here home for me in North Carolina. This is one that we just had a few months ago. And here, just prior to what happened in this case, the defendant was already in prison for some domestic violence issues related to this victim. He was about to get out. She renewed her domestic violence protective order that he could not have any contact with her. And very shortly after he gets released, the victim starts receiving calls and voicemails on a blocked number. She starts getting messages through their shared daughter's Facebook account that she believes are actually coming from the defendant, based on what they say and their tone, and so forth. And so the defendant is arrested, he's charged, and at trial, the state introduced screenshots of those posts into evidence over the defendant's objection. And the trial court said, hey, that evidence was sufficiently authenticated by the victim's testimony, and the Court of Appeals is looking at that, and they agree. There's an issue about, you know, treating the screenshots as photographs or duplicates or so forth. I think that's kind of a unique wrinkle for us here in North Carolina. But on this issue of authorship, the court says yes, they were sufficiently authenticated as coming from the defendant, even though these messages were unquestionably coming on the daughter's Facebook account. And the court based its ruling on that on just two really key factors: access and circumstantial evidence. I mean, they said he had access to the account because he was picked up from prison by the daughter who owned that account, and the daughter had a better relationship with him compared to her rocky relationship with the victim. And then also just that fact that these messages started basically right after he was released from prison. And then you pair that up with the circumstantial evidence in the case about, his history of violations against the victim, the fact that these messages were just completely unlike anything that the daughter would normally send, the other phone calls and voicemails that are all coming in at the same time. And the court said, yeah, that's enough to authenticate it as being from him. You know, again, it's that low level of proof and that common sense approach that we take to it. So, I mean, that's not just an anonymous account. That is unquestionably someone else's account. But the court said, look at the individual messages. There's enough to authenticate that. Another example I think might be interesting to you is this: Campbell, a case out of Texas. And here the defendant is, he's very angry with the victim. They're in a relationship. He's mad because she got a message from another male friend. And so later that evening, he commits this violent sexual assault against her. And relevant evidence that later comes up at trial are messages that he sent to her after the fact, basically apologizing for what he had done, admitting to it, and so forth. But on appeal, the defendant is arguing that it was error to admit those at trial because they could have come from anywhere. They could have been from anyone. He denies sending them, just says, look, there's no proof that it was him. And the court here is making the same kind of analysis I was talking about in Clemens, that they look at the distinctive characteristics and pair that up with the evidence and the facts of the case, and they say that was enough. That was correct to let that in. For example, they talk about some of the unique speech patterns that are present in the messages that are consistent with his speech patterns as a native of Jamaica and the way that he testified when he was on the stand at trial. And then also the fact that they reference this incident that just recently happened and the potential charges he's facing for it, things like that. And then they say, look, I mean, he had a Facebook account. He and the victim were the only ones who ever had access to it. And the victim is here saying she got these messages coming in his name. Is that irrefutable proof beyond a reasonable doubt that they definitely came from him? No, it's not, but it doesn't have to be. And there's a great quote in there that says, while this evidence certainly does not conclusively establish that Campbell authored the messages, in fact, Campbell insisted that he did not, the state was not required to rule out all possibilities inconsistent with authenticity or prove beyond any doubt that the evidence is what it purports to be, so long as the authenticity of the proffered evidence was at least within the zone of reasonable disagreement. The jury was entitled to weigh the credibility of these witnesses and decide who was telling the truth. For time, I won't go into the details of this last one I had mentioned up there, Recio, but it's the same thing where they have to make that final link between the defendant and the Facebook account, and they point to the name, the email, the photos on the account, the messages, and so forth. And they, again, reject that argument that, well, hey, even if it's my account, maybe somebody else accessed it. And the court said there was no evidence of that happening. The court said, quote, what matters is not whether a jury could find that Recio did not author the post in question, but rather whether the jury could reasonably find that he did, given the strong evidence that the Facebook account was Recio's, and without any evidence of unauthorized access, the jury could find that Recio was the true author of the post. The government therefore properly authenticated the Facebook post. We're getting down to the end of our time here, but I just wanted to try to boil it all down to this. all of this social media evidence. The main challenge is authenticating that evidence, showing that it's real, linking it to the defendant. But that doesn't have to be that challenging. If it's on a server, yes, there is still some kind of variation between the courts out there about whether you can call these a business record or not, or whether they're just, they're not business records, they're just computer generated piles of data. But either way, your focus is the reliability of the records you're getting from the source. And you do that by showing that they came from a trusted source. So that's how we know that they are genuine and they're real. And once we know the records themselves are reliable, then all the juicy details in those records, like the account name and the email address and the content, all of that can get you over the second portion of that, of showing why we should believe that the defendant is the person who wrote it. And of course, feel free to point to any other facts or circumstances you have that further bolster that idea of authorship. When it's in your hands, when you've already got it, now your focus is shifting a little bit, I think, to explaining to the court how you found it and how you tied it to the defendant, how he reacted in an incriminating way, how you preserved it for trial so that it couldn't be altered. So, if it came out of his back pocket and nobody has altered it since then you shouldn't have any trouble making the sufficient showing that it's probably his and therefore he probably wrote it. And that's enough to get you over the authentication burden. And then finally, for that most confusing or potentially troubling category of being out in the wild, there's no question it's real. We can go look at it ourselves online, or the witness who screenshotted it can just say, yeah, that's exactly what I saw. So it's not a question about whether it's real. It's a question about showing who wrote it. So you lean heavily, of course, on witness with knowledge if there is one, but more likely you're just taking a deep dive on those distinctive characteristics and using every detail you've got that points to who it is and why we think that's who it is. And the cases back you up that the language, the terminology, the timing, the knowledge of specific events, all of those things that show who it is are enough to authenticate that evidence as being from the person that your victim or whoever it is believes that it's from. So I had a timer running. I think maybe we've just got a minute or two. I know there were questions running in. I hope they've been covered, if not already. But if anybody wanted to jump in with one or two, I'd be certainly happy to try.
And John, this is Susan. That was absolutely fabulous. And I had gone through the questions that were submitted beforehand, and I was trying to keep up with the ones that have been submitted during the presentation. Since we only have about a minute left, I know there were a number of questions about the actual citation. It was a few minutes ago where you said it wasn't on the slide.
Oh, yes.
And it was 40 AL something.
That's exactly right. And let me just flip back through my notes. It was 40,
Sure.
40 ALR 7th 1. That's from 2019. And, it's just a research article called Authentication of Social Media Records and Communication. That was just something I came across on Westlaw, but it seemed like a good kind of collection of cases and resource, that talked about different circumstances, different jurisdictions. And if you don't have one that's just dead on point for your state, that might be somewhere to go. And even if this is from Ohio and you're in Kentucky, maybe that's something the court would at least find the reasoning to be logical and persuasive.
That's perfect. And you know what? We'll get a copy of that article if we can and share it with the attendees. And unfortunately, I mean, you do have your contact information here. So if we unfortunately, we can't get into any more additional questions, but I have to say, I think most of the questions have been answered, and I think you just did an absolutely terrific job of really demystifying this. And I think that our participants are going to feel a lot more comfortable, and I have a feeling also that this is going to be an evolving issue, so I think we're going to be doing some more presentations together, and I'm inviting, please, participants, know that if you're coming up with questions or you can be getting in touch with us. Rachel has shared the link if you want to be involved in our prosecutor or law enforcement. If you want to get our resources, please reach out to us. And we are here as a resource to help not only juvenile prosecutors, because we know that we all work together as a team, And I just want to thank everybody. And Jonathan, was there any final words you wanted to say?
No, just thanks for being here. I hope everybody got at least something valuable out of it. And if you do have a follow-up, you know, I'm mainly North Carolina law, but if you've got a follow-up about something we talked about, please feel free to email me, and I'll be happy to do whatever I can to address the question.
Thank you so much.
Great. And Jonathan, just the last few slides here, if you can go to the next slide here for me, just to wrap up everything. Just wanted to.
I'm sorry.
Oh.
I think that's. I'm so sorry. I think that's all I had on mine.
Oh, okay. Well, I can just really quickly remind folks that if you didn't get a chance to get the slides, we did indeed share them. But here, I'm going to actually just share this for those who may be filing out of the virtual room here. And so for our audience members, there's going to be a little box that will come up on your screen, and it's going to have the share file there. And on there, you can access the access the PDF of today's presentation. So that should pop up on your screen now. If you're having issues downloading that share file function that I just put up, also note that there's been a link in the chat posted several times by my co-host that is where you can get access to the item that I just shared there as well. And so let me see if I can actually just share myself. Well, it looks like I may not be able to.
Yeah, I just wanted to remind everybody too about the evaluations, which it's not up on the slide, but it is in the chat, and there's a link there to the evaluations. So we really use those evaluations to tailor our presentation. So please, please, please fill it out and send it to us. We really appreciate it.
Great. Thank you, Susan. And yes, that link is there posted in the chat. If everyone could please go in and provide that information for our colleagues with NDAA. Also note that we do have opportunity for you all to sign up for a listserv in case you're interested in doing other NDAA-related webinars that we'll host in the future. Also, I put up a polling question for folks as well here, where we essentially want to know, how do you plan to apply the information that you learned? Note that this is multiple select, and so please feel free to go in and actually get a chance to select all of the options that you so desire to let us know how do you plan to apply the information here as well. Any questions about submitting any type of TTA 360, TTA request can be submitted through TTA 360, which is the OJJDP website as well. And then if you have questions related to any of our webinars that we'll post on our website, including this one, please note that you can follow up with OJJDP TTA Help Desk, and we'll be more than happy to follow up with any supporting items that you need from any of the webinars that we have on that site. That being said, I'll go ahead and conclude today's web event. I'll leave the poll up a little bit longer for folks. But again, thank you all for joining today's web event.